Hello everybody, so welcome back to my English Law channel. So this is about the Bill of Rights that was passed in England in 1689, not to be confused with the First to the 10th Amendments of the United States Constitution. And one thing is, Americans often say, oh, well, we had the revolution to get ourselves gun rights, as in it's there in the Second Amendment. But the Bill of Rights obviously was applicable in America prior to the revolution, and indeed they regard it as part of their legal heritage to this day. So in that wise, they actually didn't need the Second Amendment because the Bill of Rights specifically say there is a right to bear arms, although it excludes Catholics. There's a lot of anti-Catholicism in Great Britain at that time. Okay, so the Bill of Rights, 1689, was passed by the Parliament of England and Wales, but its proper name is an act declaring the rights and liberties of the subject and settling the succession of the Crown. Such a mouthful that is known as the Bill of Rights usually. The subject being a person who is a citizen of that kingdom. If there's a king or queen, then you'd be a subject. I know we can say British citizen today, but they didn't used to use the word citizen until well into the 20th century. Succession of the crown is in who's the crown to go to. It's partly saying that James II is abdicated, is his daughter, Queen Mary II, and her husband, William III. They are joint sovereigns. So anyway, it's a core document of UK constitutional law. It's up there with Magna Carta in significance. Anyway, it's thought to be part of the legal heritage of various common law countries, for instance, New Zealand. Now, in Scotland, there's the claim of right, which is much the same thing as the Bill of Rights passed at the same time. So the Bill of Rights, it confers some advantages on subjects. Often it claims it wasn't a novelty, simply restating and underscoring things that had already been extant, sorry for that tautology, for centuries. Anyway, so it said that, for instance, a subject has the right to petition a monarch. Well, not a very extensive right, and they've been petitioning monarchs for centuries anyway. Anyway, so what does it go on to say? And that there are certain constitutional formalities to be observed by the Crown when they must seek permission to do various things. It reminds me, I think, of what the Declaration of Independence says, that the legitimacy of a government relies on the consent of the governed, though that's not verbatim. And the consent of the people in the Bill of Rights means as represented through Parliament. But of course, the Parliament was very unrepresentative. Only about the wealthiest 5% of males could vote and no females could vote. So the English Bill of Rights is rather different from the American version. But the first 8 amendments of the United States Constitution bear a striking similarity to the English Bill of Rights. I do say English, not British. Perhaps I should say English and Welsh. In Ireland, we weren't part of it. I know some people in Ireland, if I say that we're British, they'll go up like Krakatoa, but tough, we are British, even though most of us aren't British citizens. So the United Kingdom's got an uncodified constitution, but the Bill of Rights is certainly seen as one of the statutory elements of the UK constitution. So it enumerates various rights, such as the right to be represented in Parliament, even though most men didn't have the vote, but it was said that their elders, well, their betters were voting on behalf of them, the quality, the propertied classes, because to some extent this is about representing property rather than representing people. Unsurprisingly, those people chose to frame laws that suited themselves, as in the law was very much leaning towards the affluent. Anyway, so the Bill of Rights, it incorporated into law the sense that people inherit privileges, everybody has certain rights, and these cannot be alienated even by the monarch. And everyone, including the monarch, is subject to law. Though I have heard people argue that even today that the monarch is immune in certain respects in the United Kingdom. I can't remember what that brocard is, Rex non-fit, Cremen or something like that the monarch is above the law. Now, we're going to have equality before the law, but Prince Andrew, well, he's certainly not the monarch, but he's close to her. Why has he not even been questioned in relation to the allegations made by Victoria Roberts 19 years after the alleged incident? Even if that woman hasn't reported this alleged felony to the police are entitled to investigate anyway, and they sometimes do if they just hear a rumour. So come back to the Bill of Rights. It decided that the head of state and others who hold power are responsible towards those whom they hold power over, and therefore they are answerable to the people. They're not a law unto themselves. The Bill of Rights also underscored the primacy of Protestantism. Remember, this was in an egalitarian age, and if you did not conform to the state religion, you'd be discriminated against by law in that realm of England as you would across the globe. So, but it was a step forward for liberty in some ways by saying that some rights are protected under law, but it certainly doesn't go so far as universal rights. And this is a time when enslaving people abroad, or in Africa, bringing them to the Caribbean, to North America, bringing these people to the British Isles, was regarded as entirely permissible, and indeed even honourable. People made fortunes out of it. You know, James II, he'd been president of the Royal African Society, and its stock in trade was our own species. Anyway, so I don't want to go too much into the background, but William, Stadtholder of the Netherlands, he made landfall at Torbay on the 5th of November, 1688. People said it was a Protestant wind had blown him thither. Remember, it was an auspicious date for Protestants because obviously they remembered the deliverance of King James I when the Almighty extended his arm over his righteous servant, and he foiled the gunpowder plot. And the way that was confounded led to people celebrating with bonfire night ever since. So yeah, after disembarking at Brixham, William of Orange, he gathered his army, he marched towards London. James II saw his army melting away. They often deserted. They turned their coats, went over to the other side, including a certain John Churchill, who was the ancestor of Winston Churchill. So as he'd been betrayed by so many of his generals, James II decided discretion was the better part of valour. So he, in the finest royal style, ran away. His attempt to negotiate had foundered. There was no need for William III to do so. And there'd been a landing 3 years earlier by the Duke of Monmouth, the putative natural son of Charles II. Although he'd got some volunteers, he'd quickly been defeated. Later he had his neck stretched. Anyway, on the 23rd of December 1688, James II fled to France. He'd briefly been detained by some fishermen, but they decided to let him go. They were ordered to just let him go, and then we can say he's abdicated. We didn't overthrow him. We don't want another civil war. He dropped the Great Seal of England in the Thames, saying when he gets to the bottom of the ocean, well, they'll never find it, therefore they can't govern because they can't stamp any documents. Well, they just made another one. Anyway, so Parliament said that William and Mary were joint sovereigns of England, Wales and Ireland. Now the Irish Parliament, well, we had different ideas because most of us were Jacobites, most of us being Catholics like James II. So the Declaration of Right was hammered out by the Convention Parliament, and it was proffered to their gracious majesties at the banqueting house, Whitehall, and notably the building outside of which Charles I had been made sure to buy a head. So on the 13th of February 1689, the Bill of Rights received the Royal Assent, and then it could be announced in Parliament, le roi et la reine le veut, as in they want it, so it's approved. It's law at that point. And since then, there's only one that I can think of that a monarch has refused to sign a bill into an act to make it a law. So the Declaration of Rights was accepted. They had the throne. They were crowned in April 1689. So the Declaration of Rights was put into the Bill of Rights formally on the 16th of December 1689. So the claim of rights, it was that same year in Scotland by the Scottish Estates, as in Parliament. Estates mean like sections of society. And it was much the same thing, but proclaiming William and Mary to be King of Scots and Queen of Scots. And it was also the same month it was formalised. It was the 11th of April 1689 in North Britain, to be exact. So what's the contents of the Bill of Rights? It said that people have some rights which are inalienable. For example, the monarchy cannot interfere with the law, and the sovereign can't set up alternative law courts to the courts already established, kind of some sort of parallel system, nor can he himself sit in judgment in a case. Remember, James I had actually done that at the North Berwick witch trials. Back then he was King James VI, or King of Scots. The monarch couldn't simply order a tax, as King Charles I had done. It made this explicit, which had long been held to be custom, that taxes could only be with the express say-so of Parliament. So you couldn't be taxed without your own consent. Well, Parliament consenting on your behalf. Right, so you couldn't have a peacetime army unless Parliament agreed. They wouldn't allow a police force either, because it resembled an army, and it could be used to bulldoze the people Remember, Charles I had burst into Parliament in 1642 to arrest the 5 members. Well, one of them was a peer, actually. The birds have flown, he declared. And that's famously why, at the state opening of Parliament every year, Black Rod has the door slammed in her face, and she ritually picks up the Black Rod, her big stick, and bangs ceremoniously 3 times at the door, whence it's opened to her. Okay, so the right to bear arms, but only for Protestants. Okay, so religious discrimination. You can elect members of Parliament without interference by the monarch. Of course, if you are a major landholder, you can vote. There's freedom of expression in Parliament, and the parliamentary proceedings couldn't be interfered with by any court. That's why there's parliamentary privilege. They're immune from what's it called for libel actions, for what they say in Parliament, for instance. No cruel and unusual punishments. This is a time when hanging, drawing, and quartering was still used even into the 18th century. And unduly high bail couldn't be demanded either. So no fines or forfeitures without trial. So there was a due process was enshrined here. Some actions committed by Charles James II were declared to be unlawful and therefore nullified. So, and it's also stated that James II, by having scarpered, had thereby abdicated the throne. So they claimed they hadn't overthrown him. There'd be no betrayal. Well, that was a lie. When he tells you to go and defeat this insurrection, and then you go over to join the insurrection, patently that is treason, even if you consider it justified. So it said that the papists were disbarred from inheriting the crown, and it said, "It hath been found by experience that it is inconsistent with the safety and welfare of the Protestant kingdom to be governed by a papist prince." Papist being a pejorative term for a Roman Catholic. So there were no Anglo-Catholics back then. Catholics meant those who followed the Pope as the head of the church. So the sovereign would have to swear an oath to uphold the Protestant settlement of the country, and Elizabeth II did that down to this day. Okay, so it said that succession would pass to the heirs of that Mary, and if she died without any, as indeed she did, then to her younger sister, Princess Anne, who was married to Prince George of Denmark, after whom Jeremiah Clarke named that trumpet fanfare the Prince of Denmark's March, or there's also Denmark Hill in London, named in his honour. And if or the other possibility is if Mary died without children, then if William remarried and had any more children, go to him. Because remember, he was of the blood royal as well. He was the son-in-law as well as the nephew of James II, because William of Orange had married his first cousin. Nice, keep it in the family, which is still lawful to this day. But many people find that repulsive because the chance of your infant being born with a congenital disorder is hugely amplified by this marriage of this degree of consanguinity. So it wasn't regarded as incestuous then. And I know it's perfectly normal in certain regions of the world, like, the eastern province of Saudi Arabia, which they've got an exceptionally high incidence of sickle cell anemia and other heritable diseases. So another part of this was the provision saying that the sovereign had to summon Parliament on a very regular basis. And the Triennial Act of 1694 really copper-fastened that. Well, said it has to be every 3 years. There's a clue in the name. Because up until this time, Parliament sitting was the exception and not the norm. And Charles II had gone 12 years without a Parliament. A monarch would summon Parliament would assemble in London or wherever the monarch told them to meet, and they would conduct some business over a few weeks, and then the Parliament would be dissolved by the monarch. They'd go home to their constituencies and not meet till goodness knows whenever it was the monarch's pleasure to summon them once more. So the Bill of Rights was later augmented by the Act of Settlement 1701, and it was the Act of Union 1707. So the Bill of Rights and the Claim of Right, they did a lot to make the United Kingdom eventually a parliamentary state, and to delimit the power of the Crown. So the political and religious turmoil which had convulsed the British Isles over previous centuries were put to bed. So anyway, this led to the transmutation of Britain from being a semi-absolute monarchy into really a parliamentary government, but it's a gradual thing, it's an evolution. So the Bill of Rights is certainly an antecedent document of the United States Constitution, Some say even the United Nations, or the Universal Declaration of Human Rights in 1948, or indeed the European Convention on Human Rights of 1950. So anyway, but there are some important distinctions. The Bill of Rights says that jury trials, the United States Constitution says yes, jury trials, and you can't have bail, which is really over the top, no more cruel and unusual punishments. For a while that was held not to be the death penalty. Then the US Supreme Court said, no, death penalty is not cruel, nor indeed is unusual. Whereas, anyway, the European Convention on Human Rights now, well, has the right to life, but that's taken to mean no death penalty. Though it doesn't actually say the death penalty is outlawed as such. All EU countries have been required to outlaw it. So the Bill of Rights and the claim of right, they're still part of law in the United Kingdom, although it's been superseded by things like the Firearms Act, which has severely abridged the right to own guns. And it's cited in legal proceedings from time to time. For instance, on the 21st of July 1995, Neil Hamilton, a Conservative MP, he brought an action against the Guardian newspaper, but it was stopped by the judge, Mr. Justice May, on the ground that there was a prohibition on the courts questioning parliamentary procedures, and that was in the Bill of Rights. So the Guardian wouldn't be able to get a fair trial. So Section 13 of the Defamation Act of 1996 said an MP can waive his right to parliamentary privilege. So the Bill of Rights was used in New Zealand in this celebrated case Fitzgerald against Muldoon and others in 1976. So the Prime Minister at the time, Muldoon, he issued a statement to the gentleman of the press saying he wanted to, he was going to abolish this superannuation scheme, which is set up by the New Zealand Superannuation Act. Now, a law hadn't actually been passed to do this, but the Prime Minister said he could do it because Parliament would bring in a retroactive law abolishing the scheme. So the Prime Minister's action was challenged. There was judicial review, and the Chief Justices and the highest judge said that he had acted unlawfully because this was in breach of Article 1 of the Bill of Rights. And this is what it says, Article 1. The pretended power of suspending laws, the execution of laws by legal authority without the consent of Parliament is illegal, close quotation, because Muldoon claimed to be exercising royal prerogative on behalf of the Queen of New Zealand, that's to say Elizabeth II. So anyway, some designs of coin were struck in the UK in 1989 to mark the tercentenary of the 1688 Revolution, or as partisans call it, the Glorious Revolution. And this was alluding to the Bill of Rights and indeed the claim of right. There was a cipher there with William and Mary. Incidentally, the oldest college in America, William and Mary, is named in their honour. There was a mace of the House of Commons as well, and there was an image of St Edward's crown after King Edward the Confessor, one of only 3 English kings to be sainted. One of the others was really just King of Wessex. And there was also the Crown of Scotland in that coin. That's enough from me, so book online lessons with me in law. Toodaloo.